The justices did not say when they'd rule, but that's likely to be very soon. The court already delayed the primary to May 17th, and depending on what their decision is, that could change again. So we want to bring in our chief legal correspondent, SEEMA IYER, who also observed today's oral arguments.
And SEEMA, after the ruling, there were 3 justices and motions to have them be recused from this case. Now, I got a lot of questions for you on this one, because you know, you've been following this and I've been following this, Brian's been following this. Okay, so the first thing is, were you surprised that they were all there? Did they say anything, and were they engaging in any way in terms of what they had to say?
So I wasn't surprised, because recusal is such an impossibly high burden. Most cases where a judge is recused, it's because they have a financial interest in the case. So Justice Earls, you saw her, she was really engaged, asked a lot of questions. She was previously an executive director of one of the law firms representing the plaintiffs. And then you also saw in Michael's package, Justice Ervin, of course, he's up for re-election. So the way those maps go could affect voter turnout, could affect him. And then finally, somebody was really silent today, and that was Justice Berger. His dad is the leader of the North Carolina Senate and a defendant in this case. I didn't hear from him. Maybe Michael saw something. I watched every minute. I don't think I missed anything. He was just hush-hush in the background. But bottom line, everybody was super engaged, and I'm not surprised that anybody was not recused. Like I said, it's just an impossible burden.
But for the plaintiffs, was it the same argument that they had before when they had the 3-panel judge to even get to this point? So while they're appealing, did they just make the same argument? They have something new today to bring to the table.
You know, mostly they did make the same argument, so I was a little bit disappointed by that. But there was a few things that were brought out, and a lot of it's brought out through the justices' questionings, and that is this whole idea of separation of powers. You all learned about this in civics class, right? But today we really heard about the court saying, listen, we can't make decisions. We can't change the law. That's not our job. Even though the lower court found partisan gerrymandering, we necessarily cannot do anything about it. And the other part that was brought up today, which I was really waiting to hear, and that is the connection between partisan gerrymandering and racial gerrymandering. Everybody knows by now racial gerrymandering is against the law. Partisan gerrymandering allowed in most states, including North Carolina. And so here's really important. Justice Ervin, who you saw in Michael's piece, he said, this is really important, is partisan gerrymandering, partisan intent, a proxy for racial discrimination intent? Finally, I see a connection between the partisan intent and the racial discrimination. Of course, the plaintiff's lawyer said, yes, it is. And by the way, we should all know about this, because the way black voters vote is so ingrained, is so entrenched, is the word she used, in our environment. So we should know by now. But still, I don't think there were a lot of arguments that are going to just push this forward.
That's actually a very important piece of this, just to be able to understand that. But also, too, Michael Howland just said that we're expecting to be able to have a decision very soon. So let's say, hypothetically, that they were able to draw new maps. Is that possible to happen before the primary, which is May the 17th?
Okay, so I haven't confirmed this, but I read that in the briefs that the remedial maps, like new maps, would be due February 18th, which is next week. So that's really a tight timeline. Also important to note, this is the Supreme Court. So usually there's like this interim Court of Appeals in North Carolina, but this was already agreed upon, that it would go from the trial court to the highest court, which, newsflash, is the law, period. There's nowhere up to go if you're fighting the state ruling. So whatever these Supremes say, that is it. The only way to maybe do something creative is to find a federal cause of action to the losing party to perhaps go to the United States Supreme Court.
So just real quick, I know we have very little time, but can this be a timing issue? Like, is there a way to be able to prolong this where you don't make the cut on certain things, and that causes a bigger problem?
They could push the primary to June.
Okay.
That's pretty much the limit.
And North Carolina's been down this road before.
Yes, yes, it's been down this road a lot of times since, I believe, like the 60s.
Yeah, we've done it quite a bit. SEEMA IYER, thank you so much for staying on top of it.